Thank you very much. My name is Jeff Moulton. I was honored this past summer to be appointed to the Pennsylvania Superior Court after being nominated by Governor Wolf and unanimously confirmed by the Pennsylvania Senate. I've been on the court for about 7 months now, and while we are an under-the-radar court, I have firsthand experience now knowing just how important the work is of our court. I believe my professional strengths line up very well with the attributes of an effective appellate court judge. I have a broad range of experience. Both as a federal prosecutor, I was a law professor, counsel to both the governor and United States senator. In terms of integrity, I believe, earned my reputation for the highest integrity, and I think that's important given the trauma that our judicial system has been in the last few years. It's important to have folks with unquestioned integrity on the court. Finally, my approach to both life and to judging fits well within the norms of judicial temperament. I bring an open mind to every case. I decide cases based on the facts and the law without any agenda to bring to the table. So in short, I'm the sort of judge I think that any litigant or a lawyer should be happy to appear before, whichever side of the V they happen to be on. Thank you very much. Thank you. Well, I've had the benefit for 7 months now of experiencing the overwhelming caseload of the Pennsylvania Superior Court. One of the things I did before I started is I talked to as many of my future colleagues as possible about how they arrange their work, and I got a lot of good ideas. There is no magic bullet for dealing with the caseload. It is, as others have said, it's largely a matter of hard work, teamwork, being smart, being a quick study. We have a high volume of cases. They range from the very simple to the very complex, and I think setting a priority for those cases, recognizing early on as you look at a case, whether it's the sort of case that's going to require a lot of time and attention or one where you can delegate a fair amount of the work to the law clerk is an important part. As Judge McLaughlin said, though, all of these cases are critically important to the people before us, so everyone deserves careful and close attention. But what you have to do is you have to be a generalist, you have to be a quick study, and you have to be willing to work long hours. One of the nice things about the job is that it's a lot of reading and a lot of writing. Those are things that I love to do. It's also things you can do on the campaign trail while you're, as long as somebody else is driving as well. So I think it comes down to hard work, being smart, and a quick study. That's the key. There's no magic way to deal with it. Thanks. I think people have already mentioned several cases of real significance. I'll mention a couple that I think have the biggest impact on the work of the Superior Court right now. One, as Judge Kunstler mentioned, is the Tincher versus Omegaflex case. That's a case that involved what evidence is admissible in strict product liability cases. We are sort of every day, I think our court is deciding another case that relates to the questions left unanswered by Tincher, and I think the Supreme Court will have that again at some point, but that's certainly affecting us every day. Also, the mandatory minimum case, Commonwealth versus Hopkins, which applied a lien to several different mandatory minimum cases, statutes in Pennsylvania. That's another case that's sort of, at least I'd say every week, running into a case that has to do with the impact of the Hopkins case and a lien on other cases. So those are two cases that really affect our practice, our work every day. A couple other cases, I guess, that I've mentioned on the Supreme Court level that are significant. The Robinson Township cases, the set of cases over the last 3 years that they've decided, which really have to do more with the Commonwealth Court's business than ours, but they probably are ushering in a new era of environmental rights litigation in the Commonwealth. That's a significant case. I mentioned also the Curran versus Luzerne County case, in which local public defenders are challenged, we're given standing to challenge the funding of defenders' offices in the Commonwealth. That's going to have an impact, I think, going forward as well. Last thing I guess I'll mention is In re Bruno, an interesting case in which the Pennsylvania Supreme Court asserted its authority, concurrent with the Court of Judicial Discipline, to deal with discipline cases. I think that has some interesting impacts, and in fact, I think discussed in the recent report by Pennsylvania for Modern Courts about recommendations to change our disciplinary system in Pennsylvania. I agree that appellate experience is an important qualification for an appellate court judge, as is trial experience, frankly. You're not going to find many candidates who have experience in all of the things that the Superior Court confronts. One of my first argument sessions in the fall was a pure adverse possession case, and I had not thought about adverse possession, I think, since the second semester of my first year in law school. So you're not going to have substantive experience in everything that we do, but having experience with both the appellate process and the trial process is an important qualification. I started out with 2 appellate clerkships at the federal level in the Second Circuit for Judge Feinberg and for Justice Rehnquist on the Supreme Court, so I started out with a good appellate perspective. I was an assistant U.S. attorney for 8 years where we handled our own appeals. Didn't have a separate appeals unit, so I had a lot of experience in the Third Circuit. My most recent experience as an advocate was in 2015 defending the governor's constitutional authority to issue reprieves in capital cases before the Pennsylvania Supreme Court. I was successful there, so I'm 1 for 1 as an advocate for the Pennsylvania Supreme Court. Now my decisions are being reviewed in a different way, so I'm not sure I'll be able to keep that record intact. But in terms of approach to judging, I mean, we are an error-correcting court. Our job is to do justice. We need to get the right result for the right reasons clearly articulated, so that in cases of narrow importance to the litigants, they understand what we did, and in cases of broad importance, the bar and trial court judges understand what we did. So I think being an advocate is crucial. Obviously, we know appellate lawyers have a crucial role in making sure that we get the right result for the right reasons, and again, clearly articulated. Well, in Pennsylvania, we elect our judges for better or worse, and we'll see if I have enough time to answer the last part of the question. But one of the consequences of that, obviously, is judicial candidates, in order to be successful, have to raise money. And inevitably, they're going to raise money from lawyers and, in some cases, litigants who are going to appear before them. And that creates, I think, a legitimate concern on the part of the public about whether or not judges are going to be fair in those cases. And how do you deal with that? You deal with that either through recusal, and I've recused myself, I'm living this right now in the Superior Court, recused myself in a number of cases so far in my time, 7 months on the court, or you deal with it through notice to the parties. And so what I've done in a number of cases is had the Prothonotari's office send a letter to the lawyers explaining that one of the parties in the case or one of the lawyers in the case has contributed X amount of money to my campaign. That is out of a total of X that I've raised, or Y that I've raised. Please feel free to file a motion to recuse if you believe that you want to. I believe I can be fair and impartial, but I'm interested in your views. There are many benefits and shortcomings in terms of the various ways of electing judges. Until 1850, we appointed judges in Pennsylvania, and the Constitution was amended because there was so much corruption in the appointment process. So it's not easy to say that either merit selection or elections are better. There are a lot of benefits to the electoral process, as Judge McLaughlin said. We get to meet with and talk to a lot of people around the state. We have forums like this, which we wouldn't have, frankly, if there was an appointment process. On the other hand, the role of money and fundraising in electing judges is a serious concern and a real reason to look closely at proposals for merit selection. And we are a statewide court with responsibility for cases involving people from all walks of life and from all over the state. So it's really important that our court reflect diversity. The more diverse our perspective, the better job we can do doing justice. In my career, I've had the opportunity in over the last 10 or 15 years to be responsible for hiring in a number of different places. And I have, in each of those instances, promoted diversity in the hiring process. Most recently, I had the chance to work for Governor Wolf, really for Denise Smiler, who's the first African-American general counsel in the Commonwealth. And one of the things that General Smiler and I did right at the beginning is we noticed that we had 32 chief counsel throughout the state and not a single African-American. We worked very hard in terms of outreach, and in terms of looking for diverse candidates. In the course of a year and a half, we had 4 African-American chief counsel from 0. And it's not easy to attract folks to come to Harrisburg sometimes. So we worked hard and did a great job doing that, I think. And I did that when I was at the U.S. Attorney's Office, when I was first assistant, also in charge of the hiring committee there, worked very hard to bring a greater level of diversity. So I think it's really important. Interesting, to Judge Patrick's point earlier, I think my experience or my perspective is one of the downsides of electing judges is historically I think we haven't done as well in diversity as we have in appointment process. Happily this time, I think in this year, both slates in terms of geographic diversity and other diversity have done very well. So we actually happily have a broad and diverse group of folks running this year, but that's not always the case in elections. So again, I think I'll focus on qualification. I will agree with you. We've seen and heard from a terrific group of candidates here. Really, the Superior Court and the Commonwealth is fortunate to have as many well-qualified candidates as we have here today. I guess I'll focus on my qualifications. I have a very broad base of experience. I've been a federal prosecutor, chief counsel to United States Senator, and counsel to the governor. Again, I'll emphasize the criteria that the Pennsylvania Bar Association emphasized. I also was highly recommended by the bar in terms of professional competence, integrity, and judicial temperament. I think I fit the bill there. If you want to know what kind of judge I will be on the Superior Court, we have 7 months of my work I've issued well more than 100 opinions during that time, so plenty of reading out there. If you just want to read one, I'll mention a decision we issued yesterday in re Estate of Carter, a case in which we found that same-sex couples have the same right to establish common law marriage in Pennsylvania as do opposite-sex couples. I think that product shows my intellectual ability, quality of my writing, and my judgment as well. Thank you.